Back once again. Neblet, Beard, and Arsenault Legal Difference segment returns with attorney Matt Crotty. We're going to continue to discuss slips and falls and how an attorney can help. So, Matt, thanks for joining me once again.
Good morning, Mark. Thanks for having me back on the program this week.
Okay, we'll get right into it. First of all, Matt, who can be held responsible if you're injured in a slip and fall?
Well, Mark, on last week's program, we discussed the importance of retaining an attorney for a slip and fall accident. Well, here's another reason why it's important. So in Louisiana, the law states that the owner or custodian of property may be responsible for the damage caused by a defective condition on that property. Identifying that owner or that custodian of the property is not always easy. Here's an example. A property may be owned by one entity, then leased to another entity who at that point may hire an entity to manage or maintain the property. And all of these entities may be responsible. So identifying the proper party or parties is extremely important in a slip and fall case.
What are some factors that determine fault?
So in Louisiana, you generally need to be able to prove 4 factors in a slip and fall case. First one, you got to prove that a defective condition existed on the property. Number 2, need to be able to prove that the owner or custodian of the property either created that defective condition or if they did not create it, that they knew or should have known of the defective condition. The third one, you need to be able to prove that the owner or custodian failed to take reasonable steps to prevent or correct that defective condition. And then lastly, Mark, you got to prove that that defective condition actually caused an injury to you.
Yeah, and then you have a case. Comparative negligence law here in Louisiana, how does it apply to slip and falls, Matt?
Well, in Louisiana, fault can be assessed against all the parties involved, and that includes the injured party. The most common comparative fault application in a slip and fall case is what's called open and obvious defense, okay? And what this means is that if the defective condition is open and obvious to everyone who may encounter it, the injured party may actually be assigned some fault for the accident because he or she should have recognized that defective condition or been aware of the dangerous condition when they walked up on it.
Yeah. How can one be compensated for a slip and fall?
Just like any other personal injury case, in a slip and fall case, you can be compensated for your physical and mental pain and suffering that you endured as a result of the accident, along with any medical bills that you may have incurred or might incur in the future.
What about if you miss work due to the injuries? Obviously, can you be compensated for that too?
Lost wages are absolutely a part of the damages that you can be compensated for. If you were unable to work for a period of time due to the injuries you sustained, you can get compensated for those wages that were lost during that time. But also, if your injuries are severe and prevent you from ever returning back to work, you may be able to get future lost wages.
Yeah, and I think last week we talked back injuries are the most common injuries associated with slip and falls.
Back and lower extremity is generally what you see in slip and fall cases, just because of the nature of the fall.
This is something that people are not familiar with. You know, if they're, if they have a slip and fall accident, they have questions. What's the best way to get in touch with you at Neblet, Beard, and Arsenault?
They can call us on the phone at 318-561-2500, or they can visit us on our website at nbalawfirm.com.
All right, Matt, thanks for joining us the last couple of weeks. It's an interesting topic. People, are not that familiar with slip and fall accidents.
Well, thanks for having us on the program, Mark.
All right, Matt. We have more to come on this Thursday, so stay right here.